Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 43 of our Lakshmikant series contest, and today we need to talk about judicial review. As the word suggests, judicial review means power of judiciary to review actions of legislature and executive. As you know, our political system is having three pillars. Legislature is there to make law, executive is there to implement law, and judiciary is there to adjudicate the conflicts, right, to resolve the conflict by pronouncing judgment. So this concept of judicial review is giving power, some additional power to judiciary to keep a check over legislature and executive, that they should perform their duties as per Indian Constitution. Although this is the concept, but UPSC is going to play on the depth, on some intricacies, some details. So we are going to cover those details as well. So this concept was originated in USA, specifically in this case, Marbury versus Madison case. Mr. John Marshall was Chief Justice of American Supreme Court, who actually contributed in evolution of this concept. So by now, you are clear about the basic idea of the judicial review. Our Supreme Court says that judicial review is part of basic structure of Indian Constitution. What does it mean? It means that our Parliament cannot take away this power from judiciary by even amending our Constitution. So a protection layer is actually given to this concept. Such is the importance of this concept. Okay, and in what case actually, in which case this particular concept was given the status of basic structure? Indira Gandhi versus Rajnarayan case. Okay, so judicial review gives power to judiciary, right? Now, even though we have in India principle of separation of power, principle of separation of power evolved from ideas of Mr. Montesquieu, who said that too much power concentrated in one pillar will turn this pillar as tyrant. That is why these three crucial functions should be separated in three pillars. So he was talking about separation of power among these three pillars, right? But don't you think this concept of judicial review gives power to judiciary to intervene in the functioning of other pillars, right? And that is why some sections, some legal luminaries have said sometimes the judicial review actually becomes judicial overlapping. Okay, we are going to talk about it further. So as of now, you should know that even though we have in India the principle of separation of power of the three arms of the state, namely executive, legislative, judiciary, clear to you, judiciary is vested with the power to review over actions of other two arms. This is what I have explained to you. Now, consider a law has been made and this law is taking away some of your fundamental rights. This law is against some of the basic principles of Indian Constitution. Now, the point is how judiciary is going to act. If all the laws which are made through our Parliament are submitted before Supreme Court so that they can be reviewed and then they will be implemented, is this the practice? No. Now, how judiciary came to know that this particular concept is against fundamental right or is against some of the features of Indian Constitution? How does it work actually? So for that we should know suo motu cases. Suo motu means on its own. It may be possible that government has released this particular act, and this act has been covered in media and as well as this gazette notification, which is like the official newspaper of government. And some of our judges in Supreme Court or High Court, they have read some of the provisions which are published in gazette, and they came to know, oh, these provisions are against this particular part of Indian Constitution. These provisions are going to take away these fundamental rights of people. So in this case, Supreme Court can act suo motu as well. Suo motu means on its own. Even if none of you go to Supreme Court against this particular law, Supreme Court will act for your protection. That is called suo motu cognizance. Okay. And second is PIL, public interest litigation. It may be possible that some of you consider yourself good Samaritan. You consider that, oh, we are preparing for UPSC and we understand what are the implications of particular law are going to be. So you have read and you found that this is against Constitution. So you can actually file a PIL in Supreme Court or any High Court, wherever you are, right? In this case, now court can actually take up this case, okay? And it may be possible the particular law is abridging fundamental rights of a tribal community, okay? And you are not from tribal community. So court is not going to say, if you are not from tribal community, your fundamental rights are not being abridged, why you have come here? Court cannot say that. Why? Because this condition has been relaxed, that discontinuation of the principle of loci standi means it is not necessary that you should be the person who is being implicated or you are the true sufferer, okay? Anyone can file this public interest litigation. The word itself says public interest. You file this litigation for public interest, okay? So then judiciary can actually do the review work. Now, Justice Syed Shah Muhammad Qadri has classified the judicial review into 3 categories. What are? Number 1, judicial review to actually keep a check over constitutional amendment. For example, a constitutional amendment is against fundamental right, is against any provision of constitution, then judicial review can be used, okay? Second, judicial review can be used against some legislative action of parliament or state legislature. Means they have not amended constitution. It is plainly a law which is made by parliament or any state legislature, but if it is against the spirit of constitution, then also judicial review can be used. And third is executive action. It means if some administrative action, for example, you are a district magistrate and your action is against the spirit of constitution, your circular is against the spirit of constitution, then it can also be taken up under judicial review and your action can be reviewed, and if it is found against constitutional spirit, then or constitutional provision, then it can be declared null and void. Okay, so you need to remember 3 ways, okay? Constitutional amendment, legislative and executive. Clear? Now, Supreme Court has used this power in number of cases. For example, Golaknath case, bank nationalization case, privy evaluation case, Kesanand Bharti case, the minimum mill case. Do you remember about NJC discussion which we were having in the Supreme Court lecture? I told you that Supreme Court declared NJAC as null and void, which was supposed to replace this collegium system. So how Supreme Court did that? Supreme Court did that by using this power of judicial review, right? Supreme Court said it is against the independence of judiciary, and independence of judiciary is basic structure of Indian Constitution. Now, importance. What is the importance of judicial review? So you can remember these points. Number 1, it actually upholds the supremacy of Constitution. This country should be run as per Constitution. And who is going to ensure that? Judiciary can ensure that, but judiciary needs some tool, some power, some weapon. And that weapon is judicial review. Then to actually keep a check if executive is turning into a tyrant, right? To actually balance the federalism. What does it mean? It means, you know that our constitution has certain features which give some more power to center, right? For integrity, for ensuring integrity of India, right? But state might say, sir, this is against federalism. Center is abusing its power and taking away our power. So in this case, who can actually come into picture for balancing this by balancing this federalism? So this can be done by judiciary. Okay. UPSC even asked this question last year in prelims regarding federalism, and one of the statement was related to this, right? So you should remember, means independence of judiciary is also important for ensuring federalism in India. This should be a statement in your mind. Now, it is essential to keep a check on legislature, as we discussed, for securing independence of judiciary, right? For example, this case NJC, and for actually protecting your rights. For example, Article 32, Article 226. Our High Court and Supreme Court can actually issue writs for protection of your rights, right? And they can also review any law which is taking away your fundamental rights. So these are the, you can say, importance of judicial review. Clear? Now, constitution provisions for judicial review. Now we are going to go article wise, and some of these articles we have already discussed, but still I want to go with you article wise. Article 13. Remember fundamental right discussion. So Article 13 says that any law that is inconsistent with or derogation of fundamental rights, means any law which has been made which take away any of your fundamental rights, means provisions mentioned in part 3, then it will be declared null and void. So our constitution frameworks have not mentioned the word judicial review, but they have clearly given this scape, this you can say space to judiciary to act in this regard. Okay. Article 32 regarding fundamental rights, Supreme Court issued writs. Article 131 original jurisdiction, we discussed it, right? Just told you na, center state, right? In the previous session we discussed interstate. So interstate, center state, any kind of dispute can be taken up at the level of Supreme Court as per original jurisdiction. 132 appellate jurisdiction means a matter which you have not satisfied with, which has been already been pronounced, say at level of High Court, you can take up this matter at level of Supreme Court. 133 provide appellate jurisdiction to Supreme Court. 134 appellate jurisdiction in case of criminal. So it means civil and criminal. So 132, 133, 134, they're talking about appellate jurisdiction. Okay. You may be thinking, sir, how they're related to judicial review? These we have discussed in our Supreme Court chapter as well. So my friends, we are discussing judiciary, right? And the way judiciary can act. For example, a case has been lost in Supreme Court through appellate jurisdiction. Okay. Within that case, a matter has been raised in which judiciary need to review a particular law. So judiciary can review that particular law, but how that case actually came to judiciary? Through appeal. First, that case was, for example, a case was related to a law made by state. So first that case was discussed at level of High Court, then it came to Supreme Court, right? So these are the ways by which judiciary can actually do the review. Article 134A, certificate of appeal. I hope you remember, in High Court, if judgment has been pronounced and you are not satisfied, you can go to Supreme Court. For that, High Court is going to issue you a certificate. If you are not given the certificate, High Court is saying, no, you don't waste the time of Supreme Court. Then also you can go to Supreme Court, but for that, what you need to file a special leave petition, SLP, right? We discussed it. 135, empower the Supreme Court to exercise jurisdiction power in pre-constitutional law. I gave you example of Mullaperiyar Dam. I hope you remember, Travancore state, Madras state, right? So they were having this treaty. Now Kerala and Tamil Nadu government are actually coordinating this Mullaperiyar Dam on the basis of a treaty which was signed before constitution, right? And in that case, if there was, say, any issue, then federal court was there. Government of India Act 1935. So our constitution is saying that later the function of federal court will be taken up by Supreme Court. 136, authorize Supreme Court to grant special leave petition. Now please remember, consider you were charged in a criminal case, okay, and you were given life imprisonment. Now you want to file a case in Supreme Court, appeal, but High Court is saying no, you should not go, okay. But now you can go to Supreme Court using SLP, special leave petition. But now Supreme Court Secretariat is going to actually keep a check over the affidavits you have submitted, and it is their prerogative whether to accept your case or not. But please remember, SLP is not available to military tribunals and court martial. For example, you were serving in Indian Army, you were a major, and you were charged on some indiscipline which you have created. Now, the judgment which has been pronounced by court martial, if you are not satisfied, so you can go to AFT, Armed Forces Tribunal. You can actually move further. But if High Court, you can go to High Court later. But if High Court has pronounced the judgment and High Court said, no, I am not going to issue certificate to you to go to Supreme Court, then you cannot go to Supreme Court. Because SLP way, special leave petition way is not available in case of court martial. Please remember that. Since it is an exception case, that is why I'm saying there can be a question on this point. Okay, I hope it is clear to you now. Article 143 authorizes President to seek opinion. I hope you remember advisory jurisdiction. And in advisory jurisdiction, I gave you 2 points, right? There were 2 ways, right, on which President actually seek advice of Supreme Court. And I also told you in which case it is binding on Supreme Court to give the advice, right? Article 226, we are talking about High Court to issue writs, and I told you about that High Court's power to issue writs is elaborate than Supreme Court, right? Because High Court can issue writs for protection of fundamental right as well as legal right. Article 227 vests High Court the power of superintendence. I told you about that High Court is having supervisory jurisdiction, means supervisory power over these district courts. I told you about this logic in the start of Supreme Court chapter. So we are revising here. 245 deals with territorial extent of the laws, means if a law has been made by state legislature, till what extent this law will be applicable. 246 deals with matter of laws made by parliament, by legislature, state, for example, union list, conference list, and state list. Article 251 to 254 provides conflict between, in case of conflict between central law, state law, in case of conference list, whose law is going to prevail? Central law is going to prevail. We discussed it. Article 372 deals with continuation, for example, pre-constitutional treaties, Mulla-Periyar Ring Treaty. So it is continuing, right? Pre-constitutional law is continuing. There are many pre-constitutional laws. For example, our whole IPC, CRPC. So for example, Indian Penal Code. So it's a pre-constitutional law. But don't you think it is continuing? It is the basis of giving punishment, right? So this is continuing as per Article 372. Now, scope of judicial review. There are three grounds. Number one, FR. Means in which way this judicial review can be used. So if FR, fundamental rights, are taken away, in that case judicial review. It is if it is outside the competence of the authority which has made the law. For example, consider a law has been made and that is not taking away any of your fundamental rights, and that is also not against constitution. Can judicial review be used here? Can there be a scope there? Yes. Because the authority which should be responsible has not actually made the law. For example, you know that a state can make law on matters mentioned in state list and conference list. If state legislature has made a law on a matter which is mentioned in union list, now tell me, don't you think it can be struck down by using judicial review? Yes. Why? Because it is also against constitution, right? So this is the second scope. I hope it is clear to you by this example. Repugnant to the constitutional provision, if any law is against any constitutional provision, then it can be considered as a scope of judicial review. Okay, I hope it is clear to you now. Now, judicial review and ninth schedule. So there is an interesting twist in our constitution which happened during the time of our first Prime Minister, Mr. Jawaharlal Nehru. So what he did, so he wanted to make these land reforms. For example, prohibition of zamindari, lensing laws, etc. But at that point of time, right to property was fundamental right. So there was this fear, if law has been made, that's a good law, right, for ensuring socio-economic justice. But the point is, many people who are going to lose their land, they are going to file case in Supreme Court and High Court saying our fundamental right is abridged. And Supreme Court, High Court may say that since it is against fundamental rights, we are declaring your law, the law which is made by Parliament, as null and void. To protect the sanctity of this law, they wanted some tools, so they wanted some change in our constitution. So they made this Article 31B. So what 31B is saying? That any law which is added in 9th schedule. So in our original constitution, there were 8 schedules. So 9th schedule was added. Schedule means a list which is added at the end of constitution. So in the end of the constitution, there is a list which was added. And this Article 31B is saying any law which is added by a government in this 9th schedule of Indian constitution, then it will be considered to be, you can say, beyond judicial review. So if means Article 13, judicial review power won't be applicable on any law which is mentioned in Schedule 9, right? So I hope you understood what it was, why it was made, right? So originally in 1951, 9th schedule contained 13 acts, and now it is more than 280. Of these acts and regulations, the state, so purpose is land reforms, abolition of zamindari system. You know, zamindari system There's a farmer, there's a middleman. Middleman, zamindar, was responsible to collect the taxes and pay to Britishers. So it is under this taxation policy of Britishers. Now, in a significant judgment, IR Coelho case, Supreme Court said this is not going to continue. Means, if you are saying any law which is added in 9th schedule is beyond judicial review, then this particular precedent can be misused. Fundamental rights of people can be taken away. As of now, you have given the logic that we are doing this for good of poor, farmers. Understood. But a legal precedent can be misused by any government in future. So judicial review cannot be restricted by this mere adding of 9th schedule. And that is why this IR Coelho's case said that judicial review will be applicable even in the case of 9th schedule. Okay. The court held that judicial review is a basic structure, basic feature for Indian Constitution. It cannot be taken away. And it also said the laws which were added after 24th April 1973, they can be challenged, even if they are mentioned in 9th schedule. The laws which were added before, means before the date 24th April 1973, they will remain there. There is no need of challenge in that case. So Kesan and Bharti case was the reason of this date, because Kesan and Bharti case said basic structure doctrine is going to be applicable. Now these are some examples of amendments. So you know to cram these or date, just attempt the questions here. Which one of the following statements regarding the exercise of judicial review is not correct? You have to tell not correct. A case must be brought before the Supreme Court regarding the validity of a law. Do you think it is true or false? It is true, right? But you have to identify not correct. Unanimous opinion of all the judges is necessary for declaring a law null and void. This is false. Because I told you in the Supreme Court chapter that decision by Supreme Court bench is taken on the basis of majority. If there's a 5-judge bench, if 3 are saying we are in favor of this, then that is going to happen. Legislative enactments, executive orders may be struck down by Supreme Court. It is correct, although we got the answer. The power is implicit in the provision of Article 3. Implicit. Please remember, if UPSC make another statement and says explicit, then that statement would be wrong, because the word judicial review is not mentioned in Article 13. Now the next question, which one of the following is correct? The power of judicial review means the power of Supreme Court to set aside any. Now please read the statements in detail, because some statements would be close to correct, right? But we have to identify the correct one. The set aside any executive decision if it is against statutory law. Tell me, do you think judicial review is there to keep a check on subsequent laws, whether they are in consonance with the law which is made by legislature? No. In judicial review, our focus is on constitutionality, not any law, right? Set aside any provision of law if it is contrary to fundamental rights. It is correct. But it is saying set aside any provision of law. Now tell me, judicial review is used just to set aside a provision in law, or it can actually struck down the whole law. It can struck down the whole law. Now on this point, I hope you remember, also talked about the doctrine of severability, doctrine of eclipse, when we were talking about fundamental rights. And I told you that sometimes UPSC makes statements in which 2 statements seem to be correct. But we have to identify which is more correct, right? Which is actually exactly correcting to the statement which is mentioned in question. Examine constitutional validity of any administrative action as well as legislative provision. Strike it down if not found in accordance with the constitutional provision. Now read this question statement. The power of judicial review means the power of Supreme Court. Remember, many students are going to commit this mistake. The second statement also seems to be true, because this can happen. If there is a law and this law is having, say, 10 provisions, and 2 provisions are against fundamental rights, So we talked about this doctrine of stability, doctrine of eclipse when we were talking about fundamental right. So it means can set aside any provision of law, right? But in this question statement, the word is review means. The power of judicial review means. So do you think it means just that, or it means third statement? It means third statement. This is the actual meaning. And since this is the actual meaning, that is why the statement is correct. This is the answer. Okay. So by this, what I want to convey, in prelims exam, sometimes two statements may be correct. But we need to identify which is correct answer. So answer to judicial review means is this. Okay. Review its own decisions or decisions of any court tribunal. This is incorrect. Okay. This is not judicial review, right? To review its own decision. I hope it is clear. Now, judicial review in the Indian Constitution is based on procedure established by law. Why? Because it is saying in the Indian Constitution. So our Indian Constitution mentions procedure established by law, although at this later stage our judiciary adopted this doctrine of due process of law from US Constitution. So we adopted that, right? But mention when we talk about procedure established by law. The jurisdiction of Supreme Court of India may be enlarged by Parliament by law. I mentioned this when I was talking about Supreme Court. So I hope this part is clear to you now. So this PDF will be available in Shashank Tyagi for you Telegram group. I hope your preparation is going well in line. If you find any doubt, any question which is actually, giving you any problem, so you can just shoot me a message on my personal Insta, shashank.powerbeam. I'll be more than happy to help you out. See you.